The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to this argument before the Kansas Supreme Court. We welcome both counsel and those who are watching on our Supreme Court live channel. I will now ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 o'clock docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Monday, March 29th, 2021 consists of one case, appeal number 114919, State of Kansas versus Frazier, Glenn Cross Jr., Johnson County, briefs both sides. The appellant has reserved 10 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. This morning's argument in this case is just one of two arguments we have scheduled on this matter today. The case raises several issues, and so we have chosen to separate the arguments into two different time periods. So this morning we will be discussing what Mr. Cross has raised in his appellant's brief as issues 1 through 10. And then this afternoon we will be discussing an issue raised in a supplemental brief. Also a little different than our typical is the time period for this argument. We are allowing 1 hour each for argument. So just to give everyone an idea, we will most likely take a recess after Mr. Cross's initial argument for probably about 15 minutes. So there will be, if you're watching on our Supreme Court live channel, that will go to a message that says we are in recess, but that will give you an idea of the approximate time we will reconvene. With all of that, I would ask that counsel would please state your appearances.
May it please the court, I'm Reed Nelson and I'm representing the appellant Frazier Glenn Cross Jr. and I am present and ready for argument.
May it please the court, Stephen Howe, Johnson County District Attorney, appearing on behalf of the appellee, the state of Kansas, and we are ready to proceed to oral arguments.
Thank you to both counsel. Mr. Nelson, you may begin your argument.
Thank you, Your Honor, and may it please the court. Very briefly, I will give a highly summarized factual statement where this is a case about a capital murder conviction in Johnson County, Kansas, where Mr. Cross was found guilty of capital murder and sentenced to death. Mr. Cross went to a Jewish community center in Johnson County and he killed 2 people in a parking lot there. And then he went to the Village Shalom Retirement Center and he killed another person in a parking lot. On that basis, he was charged with 1 count of capital murder on the basis that he had killed more than 1 person. He was appointed a defense team. This case is a little unusual because he was allowed to eventually discharge them. And he tried the case self-represented throughout some of the pretrial proceedings, voir dire, the guilt phase of the trial, and then of course the penalty phase of the trial. For the most part, Mr. Cross admitted what he had done in the guilt phase. There weren't many issues in that phase, I don't believe. The penalty phase was different. He put on a handful of traditional mitigation witnesses, and then he was allowed to talk and present evidence for days on what he felt were reasons for why he had done these acts. So with that, I will start the first issue. I raised a handful of issues in the brief. to give the court just a roadmap of where I'm going, I'm going to begin with the issues dealing with the instructions and the prosecutor's argument in the guilt phase, or I'm sorry, in the penalty phase. And then after that, I'll deal with the issues about him being allowed to represent himself. So to begin with, issue number 6 in the brief is what I'll start with. This is the issue on prosecutorial misconduct. Before I really get into this, I would just note that in death penalty cases, in the penalty phase, prosecutors are under a heightened standard, a heightened duty to not misstate the law. And in this case, we contend that the prosecution misstated that the following aspects of the case called for the death penalty: Mr. Cross's motive, Mr. Cross's lack of remorse during trial, his offensive demeanor at trial, his racist worldviews, and the age of one of the victims. One of the victims was 14 years old. So these are advanced by the prosecution to establish that the aggravator had 2 aggravating circumstances in the case. One of the aggravators was that the crime was committed in a heinous, atrocious, or cruel manner. And the prosecutor advanced those aspects of the case to establish that that aggravator was satisfied and established, and to request for Mr. Cross be put to death. So far as that aggravator is concerned, ordinarily, this court considers shooting deaths not to be heinous, atrocious, or cruel. In this case, one of the victims, Ms. Lamano, was briefly aware that Mr. Cross was trying to shoot her. And so there was that evidence that went to the aggravator. But the prosecution went beyond that in arguing these other aspects of the case. It points to, it believes it was justified because it points to the statute on heinous, atrocious, and cruel as allowing it to do this. But the heinous, atrocious, and cruel statute specifically says that it's the manner that the capital crimes were committed that can be heinous, atrocious, and cruel. That does not encompass lack of remorse at trial. It does not encompass the age of a victim. It doesn't encompass a racist worldview. As bad as these things may be, it does not encompass these things. The prosecution justifies this argument on appeal and at trial by pointing to that last subsection in the statute that the jury was instructed on. That subsection says that the jury may consider for this aggravator, quote, any other conduct that it finds is especially heinous. Any other conduct that it finds especially heinous. That's how the legislature wrote it. That's consistent with the manner that it was done. So there's nothing in those very clear and straightforward words by the legislature, any conduct that encompasses those aspects of the case that the prosecutor was arguing.
Can I understand you raise in issue 6, your concern is that it's vague, it's a constitutional vagueness. Would you explain that? Vagueness typically has to do with putting your client on notice as to what aspects of the case are going to be argued and tried. And what is it about this instruction that does not put him on notice? I assume it's the any other conduct you expressly find is especially heinous. Is that what you're saying? Is that that kind of catch-all phraseology is the problem here?
No, Your Honor. Actually, and I will go into this further in the next issue, which issue number 7, I believe, is actually the vagueness of the statute issue.
All right.
So actually, in this issue, it is related. But the problem is that the legislature did, for purposes of this argument, I am going to assume that it's constitutional. I'm going to assume for purpose of this issue that that statute is constitutional.
Okay. And I'm sorry, Mr. Nelson, I had issue 6 as the vagueness, and I thought that's what you were arguing. I understand that you're more of the misconduct
Right.
prong, right? Okay, go ahead.
We'll get to
They do blend together, but go ahead.
Right, exactly. And so yes, but it's an important question because look at how the legislature, although we feel it was deficient, look at how the legislature did define that catch-all phrase. It said any conduct that the jury finds is especially heinous. Those clear. I'm sorry.
Counsel, those factors that you've identified, the hate crime, the age of the victim, aren't these just in context arguments about the circumstances that explain the conduct that occurred that day? In other words, the age of the victim, well, if you view that argument, it seems to me that the prosecutor was arguing that there was a single focus on killing as many Jewish people as possible on that day. So age wasn't a factor because he killed that victim. It just explains the conduct that occurred, does it not? Or how would you respond to that?
Yes. The focus of the aggravator is the defendant's conduct and its victim-centered. So it has to encompass the physical abuse, if any, and the mental anguish that the victim goes through before death, which is why the shooting deaths ordinarily are not heinous, atrocious, and cruel.
Doesn't the statute expressly say that it's not necessary to demonstrate victim conscious pain and suffering?
That's right.
And correct me if I'm wrong, but it sounded like you just argued that, in fact, the state does have to show conscious pain and suffering.
Well, okay, yes, under this statute, which we do contend is unconstitutional, you're right, Your Honor. It doesn't require that, it says it may. But going to the subsection that where I am right now, even this catch-all, which says you can consider any conduct. Okay, now we're back. At least the legislature has required that it be conduct. And so to get back to Justice Wall's point, no, where I would disagree with your position or your point, your question, Justice Wall, is that the prosecutor tied it in very tightly to heinous, atrocious, and cruel being these aspects. The prosecutor, there was only a brief time when the prosecutor said Mrs. Lamano was aware of what was going to happen. He characterized it as begging for her life. Okay, that was I think it was a little mischaracterization, but that was a correct argument under this aggravator. But the prosecutor, if you look at the closing argument, for most of those things that I listed, the prosecutor tied it in very tightly to heinous, atrocious, and cruel. The lack of demeanor, he said that is evil. His lack of demeanor in court is evil. So I think that the prosecutor tied those factors in very tightly to the statute. It wasn't just sort of extra things. Anyway, that answers your question.
Some of that does seem to me to be conduct, though. I perhaps not all, but for example, taking the age of the victim, the conduct was that 14-year-old resulted in that 14-year-old seeing his grandfather shot, and then seeing the gun. Well, we don't know, I guess, but then being shot himself. I think many would feel that that is heinous, atrocious, and cruel because of the sequencing of a young child observing what had happened. So why, to me, it's very hard for some of those things to separate the motive or the sequence or other circumstances from the conduct. So how do you draw, how do you split that in parts to separate the conduct from all of those other things?
Well, I think it's just how tightly it's tied into, talking about what the defendant did that day being heinous, atrocious, and cruel, and then coming back and again to the highly inflammatory, admittedly highly inflammatory fact that Reed was a 14-year-old. And specifically saying that his demeanor at trial, I believe it was quite specific. His demeanor at trial was heinous, atrocious, and cruel.
Counsel,
that it's a hate crime. That it's a hate crime.
On demeanor, why can't the prosecutor point to that as at least some evidence of cold-bloodedness in the killing, which society has historically viewed as especially heinous or atrocious?
The prosecutor could have, maybe, but the prosecutor didn't. The prosecutor didn't connect those dots and say, at the time he did it, during the manner of death. That's not how the prosecutor did it. The prosecutor said, look at him at trial.
Why doesn't the jury instruction itself, as it's framed, and actually the statute, provide that connection, that connecting of the dots for the jury? Atrocious means outrageously wicked and vile. Cruel means pitiless, designed to inflict a high degree of pain, utter indifference to the enjoyment of the sufferings of others. Heinous means extremely wicked, shockingly evil. The jury got those instructions on what they can, on the kind of the parameters of what these words mean. And why can't the prosecutor put forward the facts and let the jury figure out if this meets the definitions of what is especially heinous, atrocious, or cruel? It does provide the jury some parameters here to consider, doesn't it?
Your Honor, I don't think it does. I think it has to be, these arguments about evil and so forth have to be within the manner that the crimes were committed, the conduct of the defendant in committing the crimes. Because look, here's the problem, is that every single first-degree premeditated murder that is done with no excuse whatsoever can be viewed by some jurors as deserving of the death penalty because it's especially heinous. So every single case that comes in front of a jury, there will always be inflammatory things about that the prosecutor can then bootstrap in and say, this is heinous, atrocious, and cruel. For example, in this case, we had the very young age of a victim, highly influential, as this court is saying. What about someone who's middle-aged? When we have that, the prosecutor can say he shot him down in cold blood at the prime of his life. How about somebody who's older aged? And the prosecution actually did that also in this case, but an old age person, they're in their golden years, and there was no mercy shown. So as soon as the aggravator is read broadly and not the manner that the actual crime was carried out, the physical abuse or mental anguish, which is how it's supposed to be limited, and then those evil comments can flow from that, But as soon as it's not limited to that anymore, it leaves it wide open for every single case that comes in front of a jury for some aspect of that to be blown up and argued as heinous, atrocious, and cruel. There's no limiting anymore to the worst of the worst.
Does that argument matter in that this is an aggravator? I mean, this again blends your two arguments together. You know, we are at the bottom of the narrowing. We've already gone through the narrowing process. And in fact, as you've admitted, we've all, a couple of the aggravators are really not disputed. So we're down to just adding yet one more pebble of aggravator on the weight of weighing the aggravators and the mitigators. So in that context, is it error for a prosecutor to be arguing about these circumstances of a crime?
Yes, Your Honor, it matters very much. And the reason why is because the standard of review is whether the prosecution can prove to this court beyond a reasonable doubt that those arguments and those aspects that I mentioned did not influence the jury verdict. And I would also argue they're more than pebbles, okay? Because how is a jury not influenced by Reed's age? How is that possible that they're not? How is it a jury not influenced by the idea that this was a hate crime, that Mr. Cross had this terrible belief system where he believes he's actually justified in doing all these things? Those aspects of the case and his demeanor at trial, his uncaring, I think they said he was chuckling at trial. His demeanor at trial, that's not a mitigator. We understand that, but it's also not an aggravating circumstance. So these things these were the centerpiece of this is what motivated the prosecution to feel that death was warranted in the case. They weren't asides. This court has seen a number of cases involving multiple homicides where judges and prosecutors feel that the very harsh punishment of life without parole is an adequate and just punishment to let that person live out their life in prison and die in prison. So these aspects of the case were on top of the multiple homicide. And I believe that they're what the prosecution feel warranted the death penalty. And I think that they're what influenced the jury. So that's the harmless error test, is whether it could have influenced the jury.
Is that really the test? It may be nuanced, but isn't the test of whether it affected the outcome? Because it might be it's hard to set for us to imagine setting aside, not thinking about things. It may influence us in that way, but that does not mean that they would not follow the instructions. And as Justice Rosen has indicated, those instructions are pretty detailed in defining those acts. And that really is is the litmus test of whether or not it impacted the verdict.
That's right. Yes, so let's talk about in a little more detail on the harmless error analysis. So I believe that it is actually whether it influences, the prosecution can prove that it didn't influence the jury verdict. The reason why that is important is because there's no question, as you say, that Mr. Cross was eligible for the death penalty because of those two aggravating factors, at least one. Killing the three people made Mr. Cross eligible at that point for the jury to go to the next step. And so we have the multiple homicide aggravator. We also have Normally, shooting deaths are not heinous, atrocious, and cruel, but we have a brief awareness by one of the victims. So we have some evidence on heinous, atrocious, and cruel that the jury now we go to this next step, where the jury is balancing those aggravators, even if they're considered to be supported overwhelmingly. Let's pretend like they are, or for purposes of my argument, I'll pretend as though these are supported, these have overwhelming support. Now, the jury is looking now at the mitigating circumstances to weigh against those. And the question being is whether the jury exercising its value system, what it observed, is considering that we have, at that point, a 74-year-old man who seems pretty unbalanced in ill health. And they are also looking at an aggravator that says that life without parole, a slow death in prison is on the table. And they may very well have also read between the lines during this trial to see that Mr. Cross had depression, alcoholism, views passed on to him by his dad, and they may say the death penalty is completely unnecessary for someone of his age and ill health. We are not going to continue with more killings. We exercise mercy. We find mercy based on our value system. One juror could have said that. So it's not whether the aggravators are overwhelmingly supported. In this case, they both are not, actually. But it's really whether the prosecutor's argument now influenced the jury's verdict. And when the prosecutor points at Mr. Cross, after explaining this terrible hate belief system and says he's evil, I believe that those things are outside the manner of death that the legislature is trying to get this narrowed to. Could that have influenced that one juror who, in spite of the legitimate aggravators, would have exercised mercy and seen life without parole as a perfectly adequate response to what happened here and to Mr. Cross?
Counsel, do we have case law that essentially supports your claim that state of mind type arguments are improper because they misstate the law?
Well, in the first Kleypas case, the court said it's manner, not motive.
Can I get you to comment on the at least two places in the statute, subsection 2, which references intent, and subsection 6, which references depravity of mind? At least those two things seem to indicate to me that the legislature was in fact considering state of mind as a legitimate issue for the jury to consider.
Okay, right. So the first one was the intent that you mentioned. I don't think that was in the jury instruction, but you're talking about the statute.
I'm just saying, I'm thinking more generally.
Okay.
I'm trying to figure out, what does this statute mean? What did the legislature intend for the defendant's state of mind to be a legitimate target for an aggravation argument? Because it seems to me the foundational premise of your argument here is that the prosecutor is not allowed to argue state of mind, because what was in the defendant's mind is completely irrelevant. That's your basic argument here. And it strikes me that the statute isn't so clear. So I guess I'm asking you to walk me through the statute and help me understand how it connect those dots for me.
So the intent part that you mentioned first of the statute, I think that is referencing the intent to go commit a heinous, atrocious, or cruel crime. And that's kind of a full circle thing. Did he, and in this case, obviously that wouldn't apply. Well, did he intend to go commit the crime in a heinous, atrocious, and cruel manner? You know, through his conduct? No, he obviously didn't. He intended for these things to be very quick. And I guess that just goes full circle again to the idea of what the statute needs to be, which is it's got to just simply has to have the physical abuse and mental anguish in it. He didn't intend either one of those things.
Why isn't an intent to commit a race-based killing especially heinous and atrocious?
Because
the intent itself is heinous and atrocious.
Because it's the manner and conduct of how it was committed. It is, again, it's, I think this court has, sorry, Your Honor.
No, that's okay. We're having a good conversation. This is helpful
Okay.
to me, at least, in understanding the statute, because I think I do understand your argument. I'm just not quite seeing where it comes from in the statute.
Yeah, well, I mean, because the statute says the defendant committed the crime, the commission of the crime in a cruel manner. It's the manner that he committed it in. And later it's clarified a little more, his conduct. These are actions. It's not his motive. And I think it's so important to keep that part and the rest of it narrow, because again, where does that end?
So you would, and this is helpful for me, you would make sort of a plain language type of statutory construction argument from words like committed and conduct to suggest that the legislature meant to limit this consideration to acts only as opposed to state of mind.
That's correct.
Okay.
Acts, not state of mind. That's correct. Yeah.
And I also, just to add on to that, take it from your argument that you really are focused on the way the state chose to identify which aggravators it was going to rely upon and the way the jury was instructed. Because some of those provisions that Justice Stiegel pointed out were not included in the instructions to the jury. Do I understand that to be part of your argument?
That's right, Your Honor. The intent one that he is pointing to wasn't instructed on. They deliberately, in fact, the prosecution elected not to add his intent to commit a heinous, atrocious, and cruel crime. And I think the reason they did that was because at that moment, as they were looking at the statute, they probably realized he didn't, because it is going to have to do with the manner of death. At that moment, they understood that it wasn't the hate crime aspect or the age of the victim, but in any event.
I want to go back to one thing that you said in your argument about harmlessness. That is a legal point. It doesn't detract, I don't think, from your harmlessness argument, but it carries over into our examination of the instruction error. And if I understood you correctly, you identified as the first step to just simply be the fact that Mr. Cross had killed more than one person, and that then qualified him for capital murder and possible death penalty. But doesn't the statute require that it be both that one of those initial narrowing, but then plus at least one aggravator before the death penalty can be imposed?
Right. So, I mean, I think that, once he's convicted of the capital crime based upon the multiple homicide, okay, once the jury verdict comes back as guilty on that, now when we're in the penalty phase, all the prosecution needs to make him eligible to go on to the next step of weighing is one of those aggravators to be satisfied.
Right.
And we,
the reason that's important, isn't it, is because that means that our statute doesn't fit real nicely under any of the state statutes that the Supreme Court has examined in trying to determine in looking at heinous, atrocious, and cruel. Most of those have been at that initial first step. So would you agree that very little of the U.S. Supreme Court case law answers specifically how this fits under our framework of statutes? They're kind of mismatches.
I might not be understanding your question.
That's fair, because it's not well stated.
and it does get complicated, the case law.
Yes, and it gets back to the when they focus on which step you're at, whether you're at that stage where you're focusing on qualifying versus sentencing, and so I'm trying to. Often they have looked at qualifying, and that goes back to my question again. We've got really little dispute that here we have been qualified for the death penalty. We're really looking at the weighing of the aggravators and the mitigators. So to me, that is some distinction. I'm not sure how important that is. And so I just wanted to clarify that or just get your thoughts on what difference, if any, that makes. And so this kind of loops back to that question I asked earlier.
Okay. I am not sure what difference that makes, other than that it can get a little bit confusing to think about, and the terminology. And so the terminology that I guess that I use and in my office that we use when we talk about it is kind of, once it's in the penalty phase, there are the two steps, the eligibility, and that's what I'm calling, and I think the U.S. Supreme Court maybe calls it, when the prosecution carries their burden and they're able to show that one of those aggravators now is satisfied beyond a reasonable doubt. And so we're calling that now that person is eligible for the second step. And the second step,
and you have no qualm, or maybe you do, but that was satisfied in the guilt phase, correct?
correct.
All right, so so we're just down to what Justice Lukert talked about, the narrowing, and one of those qualifiers is more than one person, and then the other is especially heinous and cruel, correct?
That's right.
That's we're down to that. Okay, go ahead.
Yes, that's exactly right. We completely agree that one of those aggravators is completely satisfied. And that makes him now eligible for that weighing step, the selection. I think the U.S. Supreme Court calls that now, okay, he's eligible. Is the jury now going to select him through the balancing of those aggravators and mitigators? So the selection phase is really where we're talking about the harmless error analysis.
And the reason I think that may be important is because and I have no idea how whether I'm going to even come close to pronouncing this case name correctly, but I think Tualipa, help me if you know how that's said. But anyway, in that case, I read that to say that the U.S. Supreme Court is saying that when you get down to this stage, our test is there a common sense core of meaning that the criminal jury would understand? And the things that are being argued here, given the definitions that were provided to the jury, is that jury left with a common sense understanding of the core meaning of heinous, atrocious, and cruel? Are they capable of understanding that, given that?
Okay. So I think that your question is kind of now moving me into the question about whether the statute's constitutional.
Yes and no, other than to the extent of going back to our little exchange about, we have to look at how this impacts the verdict. And if we assume they follow the instructions, how does that impact your harmless errorness analysis? So that also may come into play.
Okay.
But yeah, again, these two issues are really hard to pull apart, I think.
Okay. Well, I think in the issue I just argued, if I'm transitioning now, the issue that I just argued is the prosecution going beyond even how the statute is written by the Kansas legislature. But let me now address the statute. So, as you said, we have two aggravating circumstances, and we're looking at the one, the heinous, atrocious, and cruel, and specifically that clause, any other conduct. You may consider any other conduct that you expressly find is especially heinous. Okay, I want to first be clear. We focused heavily on that clause because it's sort of a residual clause that seems to open this up to anything, any conduct. But prior to that clause, everything before that is also optional. It has some language that the US Supreme Court says is required. The physical abuse or mental anguish is a required terminology from the US Supreme Court in Maynard v. Ferguson, 30 years ago, as well as Walton. And Kleypas also said that, the first Kleypas, and says, this is how we are limiting this. But it's not required. In our statute, it is all optional. This is a real problem.
Are you suggesting the instruction as written, the any other conduct or the statute you expressly find as heinous opens up anything? I mean, isn't it, again, I think my first point was, and what Justice Lukert just discussed with you, that isn't there a kind of a common sense understanding of what the parameters are by the very nature of the instruction of what is considered heinous? The statute outlines that, specific examples are given. Why doesn't that give some guidance? It's not just any conduct, is it? I mean, I think that's what you're saying, is that the jury could consider anything. Or why doesn't the instruction as it's framed and the statute as it's framed put it in the parameters of what especially heinous means, and it's other conduct that fits that description?
Because it's all suggestive.
It's all what?
Suggestive.
Wait, isn't it more illustrative to provide meaning to that term?
Illustrative.
And why is that problematic? Because to the extent it's illustrative, doesn't that guide the discretion of the jury?
This aggravator, and it is required. My position, and I think those courts in Maynard v. Ferguson and in Walton said specifically that especially heinous conduct that is especially heinous, that is unconstitutionally vague. And we have, as you say, Justice Rosen and Justice Wall, descriptors before that, kind of, widening what examples might be. These aggravators have to limit the jury. It is required that the jury be limited, required, in their discretion making. Because otherwise, exactly as the court in Walton said, exactly as the court in Maynard v. Ferguson said, every single premeditated murder committed without justification, it's premeditated murder, can be viewed by some jurors as especially heinous under those descriptors. So it's absolutely required that they are limited. It can't be suggestive. They can't be examples. When the prosecution said at the opening of its argument to the jury on this, it said, you can consider everything that we put in evidence in deciding this. Well, where are we now? We are back to Furman, where the US Supreme Court said that we are no longer going to engage in this because we're getting arbitrary decisions because the jury does not have required guidance. They're going to see all kinds of things as heinous. They're going to see somebody cut down in midlife as heinous. They're going to see, the reasons or non-reasons. If there are non-motives by the defendant, then he's cold-blooded. They will always come up with adjectives that will strike some jurors as especially heinous and deserving of the death penalty. And that is going to result in cases that are arbitrarily decided on the basis of race, on the basis of simply that all murders to some people deserve the death penalty because they are heinous.
In this case, isn't it true that jury instruction number 6 specifically defined it? As used in this instruction, the following definitions apply, and then it defines heinous as extremely wicked, shockingly evil. Atrocious means outrageously wicked and vile. Cruel means pitiless, designed to inflict a high degree of pain, utter indifference to or enjoyment of the suffering of others. And then goes on to even talk about more: infliction of mental anguish or physical abuse before the death, continuous acts of violence begun before or continuing after the killing. And then it does say any other conduct you expressly find is especially heinous. But didn't the US Supreme Court approve of that? Even if you have a statute, if the instructions that were given were more detailed and provided more definitions?
They approved, as I say, I guess they approved the requirements. They approved these things being required. Those two aspects required. And as you just said, anything. The prosecution argued literally anything, but they're saying any conduct. So why don't these 3 murders, because they're premeditated with no excuse, why don't they satisfy that? Just because of that. Wouldn't any jury, given this instruction, decide that instruction is satisfied because they can look at any conduct? This is someone who in cold blood murdered 3 people. That's any murder. That is any first degree murder that this court will see.
Well, but also continuous acts of violence begun before or continuing after the killing.
Right. That's a suggested example. That is only a suggested example of other suggested examples, and they're not limited to that. So they can come up with their own suggested examples. When they see the autopsy photographs, which all jurors in murder cases do, why can't they use that as a result of conduct and say, well, we assign death?
What is your answer to this, Mr. Nelson? I mean, what are we to not give a jury instruction? Are we, it kind of sounds pretty black and white here that you can, is there a jury instruction that you can think of that would better define, or are we just in a quandary?
I would suggest that last clause that we're complaining about is chopped, frankly, that is chopped out. That is unconstitutionally vague. Then you go back and look at the prior instruction, all the permissive language has to be changed out of there. It's not you may, it's not, these are some things you can look at. They're not examples. This is what it means. Yeah.
If you do that, then aren't you necessarily making it a list that is discrete and can't be, and no other circumstances can be considered? I would ask that first question, and also to make it multiple
Yes,
questions. Would you be okay with this? Would you be okay with the statute and this jury instruction if everything was the exact same except for the any other conduct you expressly find is especially heinous?
No. The rest of it's not constitutional either,
Okay. And why is that?
because it makes it all permissive.
Okay, so
Because
if
these
it
are
was
examples.
mandatory, if it was mandatory,
Mandatory. It has to be
what about, would it be a non-exhaustive list?
It cannot be in a non-exhaustive list. This is the definition. And it has to be required. The physical abuse and mental anguish is a required floor. They have to find that.
Isn't there physical abuse when someone gets shot?
Or physical abuse or mental anguish. And when someone gets shot, that is not heinous, atrocious, and cruel conduct. This court has found many times. But under this statute, a jury could certainly find that it's heinous. They could just say it's in cold blood. This statute doesn't limit any first-degree premeditated murder.
So in your view, it would be more than just removing subsection F7. It would also be changing the language of F itself that says conduct which is heinous, atrocious, or cruel may include but is not limited to, and gives the list of 1 through 7.
It includes. Yeah, that's right.
You're saying it cannot do that.
Cannot do that. It's not a guidance. How do we not get arbitrary jury verdicts on this? The U.S. Supreme Court.
How can a statute possibly list every, if a person's limbs are chopped off, does that need to be in there? And then what happens when, you have 5 different factors together and collectively they make it heinous? I mean, how could a statute possibly?
This is the problem, Your Honor. This is the problem statute. This is why the U.S. Supreme Court looked at this statute many times, because it recognized that this is the statute that's a problem, where arbitrary jury verdicts can come from.
Right, but the Supreme Court also said this is a problem, so you need to be more specific in your definitions. The Supreme Court didn't say you can't, say including but not limited to, and making, you're calling them suggestions, but I think Justice Wall called them illustrations. Does the Supreme Court, the Supreme Court ultimately has held that, perhaps just in and of itself, it is not enough. But if you give illustrations, it is enough.
Well, I think maybe this is another way to answer that, is that there have to be certain requirements, certain things that are not just illustrations or examples, certain things that are absolutely required that the jury must find. And when these cases kept going back to the U.S. Supreme Court, the 2 that they approved were you must find physical abuse or mental anguish. That's kind of, in my view, a floor. That's kind of a floor. And then, you can then define other things along with that. But I think this is one of the few, almost all states have followed that definition because the U.S. Supreme Court finally hammered it out. And this court in Clapers dealt with something very similar to this. U.S. Supreme Court says, actually, you can narrow it as a court. U.S. Supreme Court, I think, says you don't have to send this to the legislature. And this court did that in Clapers. It struggled
in the jury instruction here, it does say includes infliction of mental anguish or physical abuse before the victim's death.
Right. So
this jury was advised of that.
It includes it. It includes it as an example. And it says, and any other conduct. So why isn't a premeditated first-degree murder with nothing else? Why wouldn't that fit this definition? Couldn't that always be argued as it was cold-blooded? He did it without any thought at all. It was cold-blooded, or he thought about it for a long time, and that made it even worse. Person was too old, person was too young, person was in the prime of life. Where there are no limits, and we're back to arbitrary decision-making by the jury on an ad hoc case-by-case basis, rather than this court and the US Supreme Court directing and channeling and forcing that discretion to take place.
Mr. Nelson, we've taken, I'm sorry, it looked like Mr. Wall, Justice Wall might have had a question.
Okay.
Yeah, I was just going to ask, and so F7 is really, I know you have other objections to the statute, but that's sort of, in your view, an escape hatch that allows the jury to take this anywhere, particularly with the instruction that says any other conduct you expressly find is especially heinous. Just simply doesn't provide the guidance and the guiding of the discretion that's required. Is that correct? Is that your bottom line?
That's correct, Your Honor. It's a residual clause that's wide open. This court just dealt with that in State v. Harris. You had a residual clause for a dangerous weapon where the jury was, looking between scissors and a switchblade knife, and this court said, yeah, that is too broad. It needs to be defined better than that. We can't have these kinds of residual clauses. This is worse. On a first degree, on a death case, this is worse. Any conduct.
Thank you.
That is more wide open, yes.
I've got a question if we can squeeze it in here, Chief.
Yes.
And don't get me started, Mr. Nelson, on, what is a knife? But I want to direct your attention to your issue 3, which is the judge's duty to order standby counsel to present a legitimate mitigation case. Is there any indication in the record that you can point me to that would indicate that the mitigation case that was presented was not what Mr. Cross wanted?
Well, I would say, no, I would say that that was probably the mitigation case he did want.
And so if that's the case, then you're saying that the judge had an obligation to force standby counsel to make a case that the defendant doesn't want made.
That's correct.
Okay.
Yes, and the reason, and as I think several of my issues deal with this, it is absolutely required that these proceedings have a heightened standard of reliability, which this case didn't have. I don't think any case with a pro se defendant will have in the penalty phase. They're not capable. They never will be.
So
One
it's
way to
basically,
address that.
it's your position that never can a pro se litigant represent him or herself in the penalty phase. Is that right?
That's one of my positions, yes. Yeah. Because they are not capable of it. And short of that, Justice Biles' question, another way to achieve, the judge needed to achieve heightened reliability in the case. Another way short of that, Justice Rosen, would be to have someone appointed to present a mitigation case for the jury. They deserve it. They are having to make a reasoned moral response with a blindfold on, because they are not getting a case on the defense side. This was not. These 5 mitigation witnesses that were traditional, that was such a far cry short of the job that should have been done here. The jury had a blindfold on. And you could see during voir dire, there were 2 jurors. One was a lawyer who said this can't be right. And the other one said it was a circus. So I think jurors deserve, before they make a decision on taking a human life and making that reasoned moral response, I think they deserve a little reliability in the penalty phase.
And that would have been accomplished by ordering standby counsel to present the mitigation case.
Yes, it would have. They were paid to say
I
pretty
understand
much
that, but let's just say that would have happened, and the jury still came back with finding the aggravators outweighed the mitigators. Wouldn't you be here arguing structural error, that my client was denied his right, his absolute right to present a pro se and to represent himself and in whatever capacity that he wanted to, and he was denied that right? I can't imagine you wouldn't be taking that position.
Well, I certainly find things to argue, Your Honor, but no, I think that would be a pretty weak argument if he was.
The point
able
is that
to,
supersedes the right to self-representation, supersedes the concerns you're expressing, doesn't it? Isn't that been held throughout all pro se litigation?
that what?
Right, the right to self-representation trumps pretty much any of the concerns that you're raising here.
No, I would not agree with that. I think that it has not been decided by the U.S. Supreme Court in the death penalty phase. And I think there are so many U.S. Supreme Court cases requiring heightened reliability in that case. How does pro se representation square with heightened reliability? It doesn't. There is no reliability, none whatsoever. You know, you look at the kind of a mitigation case that he ignored because he's a layperson, not just because he's unbalanced, but because he's a layperson. They have no idea, and normal lawyers, normally trained lawyers, have no idea how to pursue a defense in a death penalty case, which has got to require going towards mental illness, going towards childhood privations, going towards alcoholism in his case, depression in his case, the death of 2 sons in his case. It's through those tragedies that defendants and lay people never recognize. That's where it has to go, that make the jury understand that the person has suffered in life, and it makes the jury connect with that person and gives the jury the option of exercising the harsh punishment of life without parole as being an adequate answer for this person's future. They will never do it. Ordinarily trained lawyers will never do it. They have to be capitally trained. And I think that the juror who makes this decision, they have to leave. They ought to be able to leave feeling as though they made a reasonable response to the case, instead of sitting through 16 days of someone trying to convince them that he would have been president of the United States if given the chance. My time is out.
Are there other questions? Mr. Nelson, thank you.
Thank you.
As indicated, we will recess at this time. We will be in recess until 10:15.